Got the record button ready to go, Sabrine?
Yes, I do. Thanks for checking in. Okay, team, the time is now 1:02. Shall we get started?
I think so. People can continue to join us as we get underway.
Okay, excellent. Good afternoon, everybody, and on behalf of the Canadian Council of Muslim Women, welcome to CCMW's marriage webinar. We do have people trickling in, and just a gentle reminder to keep your video turned off and your microphone muted, just to ensure that this webinar runs as smoothly as possible for all. Thank you. We are now going to jump into just some housekeeping guidelines. Today's webinar is being recorded, and the recording of this webinar will be available afterwards on our website at www.ccmw.com. We welcome you and encourage you to revisit the content yourself and to share it with your networks. We also invite your comments and your questions, and we'll be running a live question and answer session at the end of the webinar using the chat box. You can find the chat box button. It's the sixth button from the left at the bottom of your screen. And once you click it, the chat box will appear on the right-hand side of your screen. If you think of a question at any point during the webinar, just type it into the chat box and we will pose it during the Q&A portion at the end of the webinar. You have two options when you send a question. You can choose to send it anonymously to the host, which is myself, or you could choose to send it to everyone, in which case everybody will see the question and the person posing that question. Furthermore, an evaluation link will be emailed to all participants later today. It will take about 5 minutes to complete the evaluation, and it's extremely beneficial to do it so that we can continue on to do this work. Please don't include your name on that form in order to maintain your anonymity, and the information you provide will be kept confidential and private. Only authorized individuals at CCMW will have access. And if you require any technological assistance throughout this webinar, please feel free to send me a text message or a direct message through the chat box. My phone number is 416-897-1907. And to use the chat box, you can just send a message to the host. Thank you, and I am going to go to the next slide, please. So the Canadian Council of Muslim Women is a national nonprofit organization committed to attaining equality, equity, and empowerment for all Muslim women in Canada. During the past several years, the Canadian Council of Muslim Women has undertaken initiatives to inform Muslim women, the legal profession, community service agencies, policymakers, and the general public about the differences between Muslim family laws and Canadian family laws. Previously, CCMW published Muslim and Canadian Family Laws, a comparative primer in English and French, and a series of booklets in several languages on family law topics to further its public education efforts. Our latest project in this field is the Muslim Women's Family Law and Legal Rights Project. And in this project, we've updated those documents and disseminated them through knowledge sharing workshops across cities in Canada. In 2003, CCMW took the lead in establishing a coalition against religious arbitration, composed of over 50 sister organizations, including the National Association of Women in the Law, METRAC, and the YWCA. The No Religious Arbitration Movement and CCMW's work represented an array of complex issues and events. We were successful in that the Government of Ontario made a decision to disallow the use of religious family laws under the province's Arbitration Act. CCMW was compelled to inform Muslim women about the choices they have available to them within Muslim and Canadian family laws and simultaneously educate individuals and institutions that assist them or work with them to resolve family disputes. CCMW is composed of a national board that works to further CCMW's objectives at a national level, and over 13 amazing and local chapters made up of members whose passion and hard work advance the vision of CCMW within local communities. To learn more about us, please visit www.ccmw.com. I'm now going to turn it over to Pamela Cross, the facilitator for today's webinar.
Thanks, Sabrine. Good afternoon and welcome, everybody. I'm going to, now that I've greeted you, get rid of my image here so that you can better see the slides. Welcome to this webinar, which, as Sabrine has said, is produced by the Canadian Council of Muslim Women. I'm a lawyer, and I've worked with CCMW on a number of projects over the past several years. The focus of my work with CCMW and with other women's organizations is on violence against women and the law. I'm honored to be presenting this series of 7 webinars, which reflect the content in 6 brochures produced by CCMW that provide comparative information about Canadian and Muslim family law, particularly as they pertain to women's rights. The topics covered in the brochures are marriage, which is what we're going to talk about today, divorce, custody and child support, family property and spousal support, domestic contracts, and inheritance. The goal of the written materials, as well as of these webinars, is to assist Canadian Muslim women in being able to make informed choices in the area of family law in Canada. We hope these resources will also be of assistance to professionals who work with Muslim women in the family court system, students who'd like to know more about these issues, and community-based services that assist women. These are the 6 brochures, all of which are available on the CCMW website. The content of both the written resources, the brochures, and these webinars is based on Muslim and Canadian family laws, a comparative primer, which was published by CCMW in 2006. The brochures and the webinar contain updated legal information that is current to today's date. Please note as we begin that the information contained in these webinars is just that, information. It's not legal advice, and it should not be interpreted as though it were. If you or someone you know is dealing with a family law issue, it's important for that person to meet with a lawyer, to discuss their situation, and to receive legal advice. It's only when a lawyer has been fully informed about all of the facts of a particular situation that they are able to provide legal advice. And only lawyers who are licensed and who carry the appropriate insurance can provide legal advice. The webinars, the brochures, and the primer, while we certainly hope they will be useful to you, are not a replacement for legal advice. If you want to find out about the sources and validity of Muslim laws and legal opinions referred to in these webinars, you should consult with the primer that we showed you a picture of in the previous slide. Laws in a public legal system are in a constant state of flux as they're changed to adapt to the times. What you hear in this webinar and what you read in the brochures is accurate to the date, in the case of the webinar, the date it was recorded, June the 2nd, and in the case of the brochures, the date of their publication, which appears on the brochure when you look at it on the website. We encourage you, in fact, we encourage you very strongly to verify that the information contained in these documents is current at the time you're using it. At the end of my presentation, which will take between 30 and 40 minutes, we'll have time for questions and answers. As Sabrine has said, you can pose your questions at any time by writing them into the chat area on your computer screen. When we get to the discussion period, Sabrine will read them out so everyone can hear them and then I'll do my best to answer them. Enter your questions as you think of them, rather than waiting till the end of the webinar, just so you don't forget them. Let me also just take a moment to say that I'm presenting these webinars from my perspective, my expertise in Canadian family law. The Muslim legal information that's contained in these webinars was developed by Professor Omar Farhat, who isn't able to join us at this time. So questions about Muslim family law that you may have that you post in the chat area, I'll be deferring to members of the CCMW executive. Let's talk about marriage. For some people, marriage is an important part of formalizing their intimate relationship with another person. How they do this will be different for different couples. Some will want a simple ceremony, witnessed only by close family and friends, followed by perhaps some kind of small social event. Others want a giant party so they can celebrate their union and their love with many other people. Some want a civil ceremony, others want a religious one. One thing that is in common for most people who marry is that, for the most part, people who get married want to incorporate at least some elements of their family culture into the event. What is marriage under Muslim law? Marriage in the Quran is understood as a union between a man and a woman. The foundation and most important principle of this union is peaceful companionship and tranquility. The primary purpose of marriage is the maintenance of a relationship that is built on courtesy and sympathy. In classical substantive Muslim law, marriage was understood as a civil contract between the bride and the groom. Where a contract is formed like any other contract through an exchange of offer and acceptance between the two parties, and I'll come back in just a second to explain what that means. The contract of marriage was also understood by the classical jurists as a central social institution of tremendous importance, with far-reaching effects on such socially critical issues as procreation, lineage, inheritance, and the preservation of social peace. So what does this mean, an exchange of offer and acceptance? That's a legal term that exists in many different legal systems, in Muslim law, in Canadian civil law, and so on. And it simply means that if you and I are entering into a contract, there has to have been an exchange between us. I make you an offer. For example, I offer to be your lawyer. And in exchange for that, you accept my offer and give me something for that offer that I have made to you. In the case of a lawyer-client relationship, that would be you give me a retainer, a fee of money, a sum of money that I can use to apply towards my fee. The exchange of offer and acceptance, as I've just described, is the main condition of marriage in Muslim law. And it can be done orally by the bride and groom. So I, the bride, say to the groom, or the groom says to me, I offer you this, and I accept by providing something back. It can also be done by the designated representatives or legal guardians of the bride and groom. In other words, it does not have to be done in person by the bride and groom themselves. A written contract is not strictly necessary in the classical tradition. Besides mutual consent, the contract of marriage has two other important conditions. There must be a dower, a mar or a sadaq, representing a gift to the bride, and the marriage cannot be secret. In Muslim law, a secret marriage is considered null and void. Under Canadian law, marriage is regulated through the Marriage (Prohibited Degrees) Act, which is a federal piece of legislation, and it sets out who can marry whom. So that's the federal government has authority over who can marry whom. The administration of marriage, so how the ceremonies happen and all those kinds of details, that part of the law falls within the jurisdiction of provincial and territorial governments. In other words, each province, each territory can set its own rules for how marriages take place. They're very similar from one part of the country to another, but they are governed by laws specific to a province or a territory. And in Ontario, the relevant legislation is called the Marriage Act. Under Muslim laws, in general, any two Muslims of opposite genders can get married if there are no obstacles to their marriage and if they meet the formal requirements for a valid marriage contract. In classical doctrine, Muslim men are also allowed to marry a Christian or Jewish woman. Muslim women, however, cannot marry a Christian or Jewish man, and overall, traditional doctrine rejects marriage between a Muslim and an unbeliever. In the classical tradition, scholars required a certain degree of compatibility between the bride and the groom. This typically meant a certain equivalence in social, cultural, and financial status. This requirement has generally been left out of modern laws of Muslim states, given the difficulty of determining compatibility in a modern, urban, interconnected world. Still, many religious scholars, even today, will view compatibility in the sense of proximity or similarity of values as a desirable feature in marriage. While divorce is discouraged under Muslim law, it is permissible, as is remarrying after a valid divorce has been allowed. Under Canadian law, any two unmarried adults may marry. Opposite sex, same sex, with a few restrictions, as we'll talk about in a minute. Any individual who has been previously married can remarry in Ontario if the previous marriage has been dissolved in a manner that is recognized under provincial law. And that's the same in the other provinces and in the territories in Canada too, but that's a matter of provincial jurisdiction. And as I mentioned a minute ago, for a number of years now, same-sex marriage has been legal in Canada. There are some combinations of individuals who cannot marry under both Muslim and Canadian law. Under Muslim law, there are three main reasons for which marriage between two people may be prohibited: if they're related through blood, if they're related through marriage, or if the woman is breastfeeding. Blood relatives whom a man may not marry are specifically enumerated in the Quran: the mother and all female ancestors, the daughter and all female descendants, sisters, half-sisters, aunts on either side, and nieces. A man can also not marry certain women because of other marriage relations, including mothers-in-law, daughters-in-law, stepmothers, and stepsisters. A man is also prohibited from marrying two sisters or a woman and her aunt simultaneously. Women are not permitted to marry their own or their husband's direct ancestors or descendants, siblings, siblings of parents, grandparents, and further ancestors, or anyone married to a direct ancestor or a direct descendant. The same types of prohibition in relation to in-laws arise in the case of milk kinship, whereby the breastfeeding woman is considered to be a mother for marriage purposes. There is no prohibition against marriage among first cousins. Classical schools of Muslim law allowed a man to marry up to 4 women at a time, but a woman can only be married to one man at any given time. And I'm sure we're going to come back to that topic when we get to the discussion. According to Canada's Marriage Prohibited Degrees Act, a person cannot marry someone to whom they are related by blood or adoption. For example, full, half, and adoptive siblings cannot marry. Parent-child and grandparent-grandchild marriage is also prohibited. Marriage between first cousins is generally taboo, but that's a social taboo. That's not a legal taboo. It is not actually illegal in Canada to marry a first cousin, and then obviously the same is true for second cousin and so on. But it's not thought of as a good idea. Under Canadian law, a man can only be married to one other person, man or woman, at a time, and a woman can only be married to one other person, man or woman, at the same time. There are age limits under different systems of law as to when people can marry. Under traditional Muslim laws, there are no formal age limitations on when the contract can be formed. But remember in a minute that sentence when we talk about other steps in completing a marriage. So no formal age limits on when the contract itself can be formed. Most classical scholars have granted fathers the right to promise their minor children as young as under 9 years of age in marriage. This right is specific to the father. No other guardian is allowed to promise a minor in marriage unless the minor specifically empowers that other person to do so. Even though the contract can be formed when the bride or the groom or both are minors, consummation of the marriage cannot take place until both parties, bride and groom, have reached puberty and are physically and mentally prepared to bear the responsibilities of a family. Most countries where Muslim personal status law is applied have introduced a minimum age for marriage, which is most often 18 for both women and men. In Canada, the age at which people can marry is set by provincial and territorial legislation. Canada's criminal code makes it an offense for anyone under the age of 16 to marry, and for anyone to assist in carrying out such a marriage. So if I were to be, let's say, a minister or a justice of the peace, and I officiated at a marriage where either of the people getting married was under the age of 16, I could be charged criminally as well as the people who are getting married. Otherwise, age limits are set by the provinces and territories. Under Ontario's Marriage Act, any two people who are at least 18 years of age may marry. If either of those people is between the ages of 16 and 18, they can marry, but they must have the written consent of both sets of parents. While regulations on the legal marrying age may vary from one jurisdiction to another, most are similar to Ontario's rules. As mentioned above, marriage in Islam is a civil contract that can be formed like any other contract through the exchange of offer and acceptance between the two consenting parties or their legitimate representatives, if there are no formal legal barriers to them doing so. This offer and acceptance can be done orally, as there are no formal or ceremonial requirements. For the contract to have any effect if it's entered into in Canada, however, the marriage must be registered with Canadian provincial authorities, which is important for the recognition of legal rights under Canadian law. In Canada, many, but not all, imams or other recognized religious leaders are authorized by Canadian law to register the marriages they solemnize. Alternatively, a couple can go through a separate civil ceremony in addition to a religious ceremony that would formalize their marriage under civil law and would result in it being properly registered. All traditional Muslim scholars agree that marriage cannot be secret. Any secret marriage, one that is known only by the married couple and their representatives, is void. Most Sunni scholars, moreover, view the presence of two morally upright Muslim witnesses as a formal requirement. They disagree, however, on whether it's possible for a marriage to be kept a secret between the couple and the witnesses. Whereas Malikis consider this a secret marriage and therefore null and void, Hanafis and Shafis consider the marriage valid as long as the formal requirement of two witnesses was fulfilled. Shia scholars also have differing opinions. Some say that while it's not necessary to have witnesses to a marriage contract, it's still recommended. Others agree with the majority that the presence of witnesses is a formal requirement. So you can see there's a lot of different ways to interpret the law when it comes to some of the aspects of marriage, including whether or not witnesses are required. Marriage in Ontario, as elsewhere in Canada, can be solemnized by either a civil, meaning a non-religious, or a religious ceremony. In a civil marriage, the parties purchase a license from the municipal clerk, and the solemnization is performed by a judge, a justice of the peace, or any other person who's authorized to perform marriages. There's no particular formula to be followed, but certain statements must be made by each party and by the person who's solemnizing the marriage. In a religious marriage, the ceremony is conducted by any individual who is authorized to solemnize marriage under Ontario's Minister of Government and Consumer Services. In Canada, as I said a few minutes ago, most imams are authorized to solemnize and register marriages. The person who solemnizes the union must register the marriage by completing a statement of marriage form and filing it with the Registrar General within 2 days of the event. While each province and territory may have slightly different rules about the marriage ceremony itself, they are generally very similar. And as with a civil ceremony, the two people getting married can design a ceremony that reflects their personalities, their values, their cultural traditions, as long as these small pieces of formal rules are also followed. Two adults must witness the marriage, whether it's a civil or religious ceremony. Under classical Muslim family law, no person should be married against their will. There are different requirements under different schools of law for how marriage can be concluded through a guardian, but none allow the guardian to marry a ward against the ward's will, unless the minor under 9 years of age is given in marriage by their father or their paternal grandfather. The general rule, however, is that the consent of both parties must be given in clear terms, at which point the guardian cannot withhold their consent unless they have a good reason for doing so. Canadian law does not require guardianship. However, as I mentioned a few minutes ago, when the people or either of the people getting married are between 16 and 18 years of age, that written consent of both sets of parents is required. Under Muslim law, there are different types of marriage. Sunni schools are unanimous in prohibiting temporary marriage. Some Shia scholars allow such marriages, requiring that a gift be made to the temporary wife. Under such circumstances, the marriage does not result in inheritance rights between the two partners, but children of temporary marriages are considered legitimate. Other types of marriage that have been unanimously prohibited include marriages in which the bride had been engaged, that is, promised in marriage, to two men simultaneously, and cases in which two men promise minor females under their guardianship to one another, in effect doing an exchange of wards. Marriage in Canada must be registered in court by way of a civil or religious ceremony. For people who choose not to marry, who choose to live in a common law relationship, those folks can contract to set out their rights and responsibilities through a cohabitation agreement. And we'll talk about that more in the upcoming webinar on domestic contracts. And as I've already mentioned, same-sex marriage has been legal in Canada since 2005, so for 15 years. Traditional Muslim doctrine, as I mentioned briefly already, grants men the right to marry up to 4 women simultaneously, whereas women may only marry one man at a time. Classical doctrine established a number of conditions on a polygamous husband aimed at ensuring fair treatment of all wives. These conditions include ensuring that he has the financial ability to provide for all of his wives and imposing an obligation on him to care for all of them equally, financially and in terms of time spent together and affection. Both bigamy, having 2 spouses at the same time, and polygamy, having more than one, are prohibited under Canadian criminal law. Anyone who enters into such a marriage, as well as anyone who celebrates, assists, or is a party to such a ceremony, is liable to being charged criminally and, if they're found guilty, to facing a maximum penalty of 5 years imprisonment. So just to be clear about who falls within the catchment of that particular law, it would be the individuals getting married, the person performing the marriage, and anyone else who's part of the marriage, assuming that those people know that the man already has at least one other wife. Despite the fact that that law exists in Canada, there have been very few prosecutions for bigamy or polygamy over the past century. The one exception is the conviction in 2018 of two religious leaders from the Fundamentalist Church of Jesus Christ of Latter-day Saints who were found guilty of polygamy, as I say, in 2018. That was a case that made a lot of headlines. It took, I think, close to 20 years from the time that the outside community first learned about this polygamous community, which lives in the interior of British Columbia. Both of these men had upwards of 20 wives, or I should say each of these men had upwards of 20 wives and many, many children. They were found guilty. Their sentence at the present time is house arrest, and they have both appealed their convictions. So that case will continue to make its way through the courts of Canada, eventually arriving at the Supreme Court. Their argument is that polygamy is an element of their religion, and that to deny them the right to have multiple wives is a denial of their charter-protected right of freedom of expression. And eventually, I'm certain the Supreme Court will rule on this. It will be very interesting to see what their ruling is. There's lots of arguments to be made on both sides of that. Whatever a person thinks about polygamy, there are many arguments to be made on both sides of the question of whether or not it's an essential component of freedom of religious expression. The legal status of the subsequent wife or wives, so in other words, the wife or wives who are not the first wife, the legal status of those wives in a polygamous marriage in Canada is ambiguous. If the woman entered into the marriage knowingly, in other words, she knew that her husband already had another wife or wives, then her marriage is valid only under religious law. It's a religious marriage. That means she has no rights under civil law. However, she may have some rights if she can prove that she was unaware of her husband's existing marriage. If she entered into a polygamous marriage in a country where that is legal, she may have some rights under provincial family laws in Canada. Ontario's Family Law Act, for instance, does allow a subsequent wife who entered into a polygamous marriage in a country where polygamy is legal to have some rights to property division and some rights to spousal support. Generally, though, women who consent to a polygamous marriage on the basis of religious or cultural beliefs are in a very vulnerable position under Canadian law. There are basic rights as well as duties that follow from the conclusion of a valid marriage contract in Islam. As we saw, dower is due to the bride by the groom. Technically, dower is a condition of the validity of the marriage rather than a duty under the contract, although often payment of part of the dower is deferred. Classical Muslim scholars agree that the husband must support his wife financially, including providing a suitable place to live, sustenance, and clothing. The husband also provides for the children. The degree of financial support and the exact amounts and goods to be provided varies according to the husband's means and to what the wife had been accustomed to prior to marriage. Some classical scholars also believed that a husband must provide domestic help to his wife upon request if she's not used to performing domestic chores and if he can afford it. The wife's primary obligation under the marriage contract is to live with the husband and provide companionship. All other alleged obligations are subject to much disagreement among the classical jurists. A majority have argued that the new mother is under a legal obligation to breastfeed her infant if she's physically capable of doing so, but other jurists have held that there is no such obligation. The majority of scholars viewed house chores as optional for the wife, maintaining that the husband may be under an obligation to provide help under certain conditions. However, some have argued that if the husband cannot afford to provide domestic help and the wife is accustomed to doing domestic work, then she must help with the housework. The classical jurists viewed the distinct obligations of each spouse as reciprocal and interdependent. If a wife leaves indefinitely, rather than simply going on a visit, the husband is entitled to suspend financial support. On the other hand, if a wife leaves the home because the husband is unable to support her financially or pay her dower, she is not considered in breach of the marriage contract. It's very important to note that withholding sexual intercourse is not considered disobedient under the classical doctrine. In Canada, marriage contracts can be made under provincial and territorial legislation. They can include any number of stipulations that define the rights and duties of both spouses within the marriage. These are optional. The vast majority of people who marry in Canada do not have a marriage contract, but some people do because they want to set out in writing exactly how they plan to make their marriage work. There are some matters, however, that cannot be dealt with in a marriage contract and would be unenforceable if they were put in there. Anything relating to the children, for example, cannot be stipulated in a marriage contract, as such decisions are made based on an assessment of the best interests of the child at the time. So, for example, a marriage contract could say that even though I'm bringing $5 million into the marriage, my spouse agrees not to make a claim to share in that property or the value of that property if our marriage ever ends. But we cannot say in our marriage contract that if our marriage ever comes to an end, the children would live with me, because that decision is made at the time we separate, if we do separate, and it's going to be based on what seems to be best for the children at that time. In most cases, marriage contracts in Canada cannot limit a spouse's rights to occupy the matrimonial home. So while the value of the property of the matrimonial home has to be shared equally, and we'll be getting into the details of that in the webinar where we talk about spousal support and family property, the contract can't say if our marriage ends, spouse A or spouse B must leave the home immediately. In Canadian law, provisions that would make the rights of one party dependent on remaining chaste are unenforceable. It's very important that women seek independent legal advice before they sign a marriage contract. There are many ways in which somebody could sign away their rights without fully even understanding that they have those rights, let alone what the implications are of signing them away. And the only way to help make sure that a woman knows the rights is for her to meet with a lawyer. Then she can sign them away. There's no law in Canada that says you cannot sign away your rights. You're allowed to sign away your rights, but you need to have had independent legal advice to ensure that you understand what you're giving up. Even if conditions in the agreement are unfair, once it's been signed, the courts usually cannot intervene and set it aside. We'll come back to this in more detail in the upcoming webinar on domestic contracts, but I'll just make two other quick comments about it right now. And that is to say, first, if someone has been coerced or if they have signed the contract under duress, or if the other person has not shared all of their financial information or has been dishonest about it, any of those provide the basis for the contract to be overturned or set aside. But people are allowed to sign away their rights. People are allowed to make bad choices or bad decisions or decisions that other people don't agree with by entering into a marriage contract. Finally, and then we're going to move to some questions, under Canadian law, physical and sexual abuse of any kind within the marriage is illegal, and those behaviors can lead to criminal charges. Of course, emotional abuse is also something that shouldn't be happening within a marriage. There's no criminal law against emotional abuse, but it would be information that the family court would be interested in knowing about in resolving the issues that arose at the time that the marriage came to an end. So that's an overview of marriage under both Muslim and Canadian law. I'm sure there are lots of comments, probably even some questions. And so let's get the chat room up there. I think I can pull it up on my screen too. And then I'm going to turn to you, Sabrine, to help take us through the questions.
Sure thing. Thank you so much, Pam, for such a comprehensive review of marriage. I am going to get straight into the questions. The first question is, one of the elements of a Muslim marriage includes a dowry. Does this make a marriage without a dowry void? And if someone got married without a dowry, can the marriage terms be modified at a later date?
So I'm going to turn that question over, I hope, to Nishad or Nina or another member of the CCMW board.
So it's Nuzhat here. There is a requirement for there to be a dowry or a mahar, but it can be, $1. I mean, it could be. So it's just, it's part of the marriage process, but it can really be a small amount or a large amount or whatever, but the agreement happens at the time that the marriage is taking place, that there is a mahar or a dowry, and the amount is usually in the currency of the place where the marriage is taking place. And other than that, I don't think there are other conditions or issues. Maybe someone else can comment on this, but that's my understanding.
In other words, there shouldn't be a financial impediment to having the dower because it can be of a very minimal value, financial value. Yeah,
that's correct.
Okay.
It's part of the marriage contract process.
Mm-hmm.
The marriage
Well,
contract.
it fits within the Muslim law understanding of marriage as a contract where there is an offer and acceptance.
Exactly.
Mm-hmm.
That's precisely it.
May I say something? This is Amira.
Hi, Amira. Yes, please do.
Okay. And the dowry can be modified afterwards. The amount can be modified afterwards.
Thank you.
You're welcome.
Okay, Sabrine, another question.
Great. Next question.
Can I say something?
Yes, let's take one more comment on this and then we'll move on to the next question.
Okay, so my understanding is that marriage without the mention of meher is valid, but wife will be entitled to a meher which is similar to her peers. So it could be her cousins, her other women in her family or people in her surroundings. But a marriage itself will happen.
Thank you.
Great, thank you. I'm going to move on to the next question. Can someone performing a religious marriage for someone under the age of 16 be charged based on Canadian laws?
The short answer to that question is yes, because nobody under 16 can marry in Canada, whether that's in a religious marriage or a civil marriage. Now, if it's a religious marriage of any religion and that marriage is never registered with the state, when it's never made into a civil marriage by virtue of the proper documents being filed, this is where the law gets really ambiguous. If and I say this only to make the point really simple, I'm not intending, and I hope I don't sound like I'm being disrespectful in any way, but if I were to decide today that I made myself some kind of religious leader of my own my own religion, and I married people in my backyard, as long as we never, or they never, attempted to register their marriage as a civil marriage in Canada, as long as they didn't later, let's say, go to court and try to get a divorce, we can do whatever we want in my backyard. But it doesn't have any legal validity in Canadian courts. And it also means the person doesn't have potentially the protection of the Canadian law.
Thank you, Pam. There was a comment stating that breastfeeding is an important issue in marriage and should be talked about and explained more. But the next question is, does Canadian law override Islamic law in Canada? If, for example, a woman marries a man fully aware and consenting to becoming a second wife, is that considered a legitimate marriage? Where is the limit to freedom of religion? What is the fine line?
Well, it is a fine line. It's a waving line. And we're not going to resolve this issue in the time that we have together today, or even if we stayed together till midnight tonight. It's a fascinating topic of conversation. Here's a short answer in terms of the Canadian law. So I'm not trying to be philosophical or religious at all, just commenting on the Canadian law. Canadian criminal law trumps pretty much everything else in this country. And so if I marry someone knowing that that person already has another wife or wives, and the authorities find out about it, I can be charged, my spouse can be charged, the person who performed that ceremony can be charged. But as I said when I was talking about the British Columbia situation, those charges are almost never laid. This leaves women in a very vulnerable position where they live in a country that has decided that multiple wives is illegal. Having multiple wives is illegal, but the authorities seldom enforce that law.
Thank you, Pam. Next question. If I would like to get married Islamically to my same-sex partner, can I use Canadian human rights law to force an imam to recognize the Islamic legitimacy of my marriage?
That's another really complicated question to answer. You guys have got some really good ones this afternoon. The Charter of Rights and Freedoms generally it applies to public institutions, which makes a certain number of exemptions for religions. So, for instance, in Canada, while same-sex marriage is legal, religious leaders of any religion are not required to perform those ceremonies. If I am a priest, an imam, a pastor in a religion that doesn't believe in same-sex marriage, and two women or two men approach me and ask me to perform their marriage, I'm allowed to say no. Just like in some other areas, people's religious or ethical beliefs are allow them to exempt themselves from doing something that they feel violates those religious or ethical beliefs. If the two people who are entering into the same-sex marriage are looking for religious affirmation of a marriage that they have had taken part in under civil law, then I would suggest that they want to find a religious leader who genuinely is supportive of their marriage, rather than trying to convince somebody who's opposed to it to give them some kind of legitimacy that way.
Thank you, Pam. What is the Canadian law on child brides?
Well, as we've talked about already, it's not legal for anybody under the age of 16 to marry. And so that, and even between 16 and 18, that the parents must provide written consent. So I think that is really the way the Canadian law has dealt with the issue of child brides.
Thank you. The next question is, we know the rate of polygamy within the Muslim and other communities not only exists, but is also rising. Why are we not seeing prosecutions given that this is very clearly illegal in Canada?
Well, this is speculation on my part. Although I've read a fair bit about criminalization of polygamy in Canada, I don't consider myself to be an expert on it. I honestly think that for the most part, the authorities are waiting to see what happens to this big case in British Columbia. They're waiting for the Supreme Court of Canada to make a decision about whether or not religious freedom trumps the law against polygamy. And if let's say the Supreme Court says, no, despite religious freedom in the Charter, polygamy is against the law in Canada, I think we would see an increase in the number of prosecutions of that crime. Part of the problem, though, and there's two elements to this, is that very often the quote-unquote victim of the crime, so the subsequent wife, doesn't see herself as a victim and doesn't wish to be involved in a criminal prosecution of her spouse. The other challenge is that if that ceremony happens in a religious setting and is never registered as a civil marriage in Canada, there's a legal question about whether it's even a marriage for the purposes of the law. So this is such a thorny, complex issue. I love thinking about it. I love talking about it and listening to other people's perspectives on it, but it's certainly not cut and dried how we should proceed with this topic. Nizet, I don't know if you want to weigh in any more on this, because I know that CCMW has done some work in this area and has a position.
I mean, yes, we have a position, and it's primarily based on justice and equitable treatment. And our reading of the Quranic verses is that the requirement to treat each wife equitably and fairly is a tall order. And given that we have our premises belief in equality and justice, our position is that polygamous marriages, we don't support them. Our position statement says that we don't believe that, first of all, it's not a requirement. And secondly, they're harmful because the treatment of one versus another wife it would be very difficult to prove equitable treatment. So our position is that that they should not happen because they're contrary to equality rights of Muslim women.
And particularly because it only flows one way. Women aren't allowed under most arrangements of polygamy to have multiple husbands. But I agree with you, Nizat. I think the idea that one husband could treat multiple wives exactly identically, it's impossible to do. It's impossible to measure. And, there's bound to be feelings among those wives of differential treatment. So I notice here in the questions that somebody has, this is still on the subject of polygamy, has pointed out the difference between polygamy and polyamory. And again, not to get into a really, really deep philosophical discussion in the amount of time that we have left, because I see there's a lot of other questions, but that comment's absolutely correct, that polyamory is something quite different. It's not illegal. That's, where people have multiple intimate partners, but they don't necessarily enter into marriage with any of them, or perhaps they marry one, but openly the two of them are also involved intimately with other people. So that's not against the law. What's against the law is when you formalize that relationship, that intimate relationship, so that one person has multiple partners to whom they are officially married. Back to you, Sabrine.
Okay, great. I'm just picking and choosing now because of time.
Sure.
Which one? Sorry. Okay, so what is a wife to do if her husband and sponsor simply neglect her and ask her to leave Canada without implying a divorce, nor is there any abuse, except perhaps light emotional?
Well, that's hard to answer too, because I would say that first part of the sentence, in my world, isn't slight emotional abuse, that's significant emotional abuse. Generally, in Canadian immigration law, if the sponsor withdraws their sponsorship, the person being sponsored no longer has legal status in Canada and would have to either leave the country or make an application for refugee status, perhaps begin an H&C, a humanitarian and compassionate grounds application to remain here. Any woman in a situation like the one that you've just described, Sabrine, should talk to an immigration lawyer as soon as possible to find out, make sure they know exactly what stage of their sponsorship they're at, and what the obligations of their sponsor/spouse are towards them.
Okay, great. The next one says, if the religious representative does not file the marriage registration certificate, does the government follow up with the spouses to make sure it is registered?
No, because the government wouldn't even know that they had gotten married. It's really important that that registration piece happen, whether it's a religious leader, a judge, a justice of the peace who's doing the marriage. The two people getting married need to sort of stay on top of that person and make sure that the paperwork gets filed. They'll be fine until, let's say, they decide they want to get divorced, and then they realize, oh my goodness, we were never actually officially married. which can create some problems.
Thank you. If meher is a part of a prenuptial agreement, would it be enforceable by law?
The short answer is yes, and you're going to have to come back to our webinars on property division and domestic contracts for a more fulsome discussion of the question.
May I just comment? I'm not going to talk about that particular issue, but there's a lot of discussion in the chat about the mahar. And yes, there are differences among different schools of thought. And there's a very good recommendation on reading a piece by Keisha Ali. But if you should also consult our comparative primer, because it explains in greater detail the whole concept of mahar. And yes, it does not have to be monetary only. And there are some differences in the different schools of thought. We could probably have whole webinars on each of these different topics, but I just wanted to mention that. Thank you.
I would also follow that up, Nizat, by promoting the Islamic marriage contract that CCMW developed a few years ago, because I think that's really helpful in terms of these discussions that we're having this afternoon as well. I think that somebody's unmuted because we're getting a whole lot of background noise. Can everybody just check your mic and make sure you're muted? Thanks. I think we've got time for maybe one or two more questions. Do we, Sabrine?
Okay. Yeah, it's 1:57. I hope we can squeeze some in. Can you please explain how a marriage should be registered to guarantee their rights under civil law?
Anybody who's getting married in a religious or civil ceremony has to ensure that the person who's conducting the ceremony is licensed under, in my case, because I live in Ontario law, but whatever province or territory you're in. So you ask them, are you licensed to perform marriages? That's the first step. The second is, do you have all the right documents? And they're documents that the officiant, the religious officiant or the civil officiant, will complete in part before the ceremony. Some things get signed. For instance, the witnesses sign at the ceremony. That's what has to happen. So the two people who are getting married do have a role to play in making sure that they're working with someone who has the legal authority to perform a marriage in Canada, and that they know what they're doing in terms of the paperwork.
Thank you. If two Canadians from the same culture go back to the cultural country of their parents and do a nikah there, do Canadian courts accept I assume this means divorce, but nikahnama means the marriage contracts made in the other country of their parents' origin through the couple themselves are either born Canadians or Canadians not by birth?
Generally, and please understand this is a general statement, and remember what I said at the beginning, this is information and not legal advice, but generally, Canadian law will validate a marriage contract, or a divorce from another country if it was performed in accordance with the law of that country, even if that law is different from the law in Canada.
Thank you. Do you want one more question, Pam?
Yeah, let's take one more question.
Okay, there's a few on meher and one on divorce, which I'd like us to wait for the divorce webinar. There's a question that says, would you ever bring an imam or Muslim scholar on the panel in one of these sessions? And Nazhat,
that's a question for Nazhat to answer.
Yes, we would. I mean, we had invited Omar, but he's the one who completed the Muslim family law part of our materials, the brochures that Pam referred to earlier, which you can actually read. But he was unavailable for this webinar series. But certainly, there are others that we could invite if you would like, that is, if they're available.
Okay, great. The time is now 2:00. For the rest of the questions, we have copy and pasted them into a document so that we can go back to them and create an FAQ. I think that's it for the questions now.
I'm just going to,
Yeah.
before I turn it back over to you, Sabrine, just really encourage you any of you whose questions we didn't get to come to the subsequent webinars, because a lot of your questions relate to topics that we'll be covering over the next several weeks. So back to you, Sabrine.
Awesome.
We've done questions. There we go.
Yes. So our final slide, essentially. So we want to thank you in advance to everybody who joined this webinar. We will be sending you a link to the evaluation by email very shortly. It's only about 5 minutes to complete, and it really, really helps us tell our funders what we are doing and why we need to do it. So we deeply appreciate it in advance. And that's really it. I think the last slide, we have upcoming webinars, so they're happening every Tuesday until July 7th. You can register online. The information can be found on our social media by joining our mail list and by our website. My colleague Zainab, who is also on this chat here, is doing a phenomenal job disseminating that information. And if you require any more information, please feel free to email us. And the email is stated right over there. So thank you on behalf of the Canadian Council of Muslim Women. Thank you to Pam Cross for such a phenomenal job, and to Nuzhat as well, and each of the participants for taking the time to join us in this webinar today. Thank you.
Let me also thank all of you. Great.
I add my
Amazing.